So, in the last class, we have discussed the very important topics such as Indian Constitution, judicial system, schedules of the Constitution, idea of the Constituent Assembly, fifth schedule, democratic republic, constitutional adoption of the Constitution, Independence Act 1947, strength of the Constituent Assembly. Then we have, most importantly, we have seen the sources of the Indian Constitution, such as Government of India Act 1935, British Constitution, USA's Constitution, Irish Constitution, Canadian Constitution, Australian Constitution, Weimar Constitution, Soviet Constitution, French Constitution, South African Constitution, and as well as Japanese Constitution. We have also seen the history of preamble, where preamble originally was called as objective resolution because moved by Jawaharlal, passed by the Constituent Assembly. Then we have seen the committees of the Constituent Assembly, Union Powers Committee, Union Constitution Committee, Provincial Committee, and Drafting Committee. Now, let us continue the understanding the Drafting Committee. In the last class, we have already understood the Drafting Committee. Let us revise. The Drafting Committee was established on August 29, 1947 within the Constituent Assembly. It was given the responsibility of drafting the Constitution for India. This drafting committee was headed by Dr. B.R. Ambedkar, whose full name is Dr. Bhimrao Ambedkar as chairman. The committee comprised of 7 members. Most of the questions which come through this is what are the names? The names were the other members along with the B.R. Ambedkar are N. Gopalaswamy Iyengar, Dr. K. M. Munshi, Sayyid Muhammad Sadullah, Alladi Krishnaswamy Iyer, and the other 2 important names are N. Madhava Rao. Now please remember N. Madhava Rao was replaced. N. Madhava Rao replaced B.L. Mittal, who resigned due to ill health, and another name T.T. Krishnamacharya, replaced D.P. Gaitar, who expired in 1948. Now, once all the drafting committee made deliberations and considerations for the proposal of the committees, drafting committee presented the initial draft of the Constitution in February 1948. So, the very first draft was given in February 1948. Now, as we remember that the first session of the drafting committee happened. It was established on August 29, 1947. Then we have subsequently the draft committee, the draft constitution was put through for the public review for almost 8 months, and a revised draft was again published in October 1948. So first draft was put in February 1948. The subsequent draft was put in October 1948. So this was the journey of creating constitution for independent India. Now let us know about a topic called Purna Swaraj. What is a Purna Swaraj? Purna Swaraj means complete independence. Now, as we know that there are 2 most important dates. On 26 January 1950, we celebrate our Republic Day. Now we have to remember that on 15th August 1947. 15th August 1947, we got our independence. And why only the 26th January 1947 was selected, 26th January 1950 was selected as the Republic Day is the Indian Constitution came into effect completely on 26th January 1950, which is now celebrated as Republic Day, or it is also called as Commencement Day. Now we have why this 26 January was selected. This is very important. 26 January in 1930, the Indian National Congress under the presidency of Jawaharlal Nehru proclaimed Purna Swaraj, and from that time onwards till August 1947, we used to celebrate this 26 January as Purna Swaraj Divas. To commemorate this Purna Swaraj Divas, we selected the Constitution. We selected 26 January as the Republic Day or the Commencement Day. Next, as we see the Constitution, features of the Constitution, one of the features of the Constitution are the unitary features. One of the features of the Constitution are the unitary features, and the other features are called federal features. Now let us let us note down some of the unitary features of the Indian Constitution and the federal features of the Indian Constitution. Now all the students who are listening to this lecture, kindly note down or have this short copy with you so that you can note it down and remember. You might get a question. Some of the unitary features of the Indian Constitution are single citizenship, strong center with extensive powers, appointment of governors by the president. Let us take a break of 3 minutes, 1 or 2 minutes, again we will start. Please note, then there is an option. There will be an option. Slide. Set there is good option. Mic option. the break, let us understand the unitary features of the Indian Constitution. The unitary features of the Constitution of India are single citizenship. Now please note down India, the citizenship provisions in India are given under Part 2 of the Constitution of India from Article number 5 to 11. Single citizenship. Second unitary feature of the Indian Constitution is strong center with extensive powers. Strong center with extensive powers. As we see under Schedule 7 of our Constitution, there is a union list. In union list, there are 97 entries. So we can say that the center is strong, the union is very strong with extensive powers. Then we have appointment of governors by the president. In Indian scheme of polity, the governors are appointed by the president. Emergency provisions granting significant authority to the central government. Emergency provisions are given under part in our parts of the Constitution under Article number 352, 356 and 360, where emergency means suspension of application of fundamental rights. Whenever Article number 352 is invoked, there will be suspension on the application of fundamental rights. This feature has been taken from, remember the provisions of emergency has been taken from British common law. The suspension of the fundamental right during emergency is taken from Weimar Republic, that is from Germany. And integrated judiciary. As we have understood what is integrated judiciary, which means Supreme Court is at the top. Under Supreme Court, there are high courts, and under high court, there are subordinate courts. It is called as integrated judiciary. And one more feature of this integrated judiciary is that the central government can review the state government decisions, as well as the high courts can review the central laws. So this is the feature of the integrated judiciary. After understanding the unitary features of the Indian judiciary, let us see the federal features of the Indian judiciary. Now, federal features are division of powers between central and state governments. The division of power between central and state governments, the example is that under Schedule 7, under Article 246, we have a concurrent list, that is list 3, where entries are given where both the parliament as well as the state assemblies can legislate laws. Then we have existence of both central and state government is also one of the federal features of the Constitution of India. Then supremacy of the Constitution. Please remember that supremacy of the Constitution is the federal feature of our Constitution of India. Written Constitution delineating powers. Now we know that our Constitution is a written Constitution as similar to the US's Constitution. As Britishers doesn't have any Constitution, they have unwritten Constitution. Their system is called as common law. But we adopted a Constitution, we wrote our Constitution by our hands, which comes under the federal features of the Constitution of India. Then we have Supreme Court as the ultimate interpreter of the Constitution. Now, as per the Constitution, there are three organs. One is the judiciary, one is the legislature, and one is your executive. The primary job of the judiciary is to interpret the Constitution. The primary job of the legislature is to legislate the Constitution. And the primary job of executive is to implement all the laws, execute all the laws passed by the legislature. So, representation of states in the Rajya Sabha. Now, please remember in the schedule, in which schedule does the allocation of seats in the Rajya Sabha officially in our Constitution? Rajya Sabha is called as Council of States. Under Schedule 4 of the Constitution, the allocation of seats in the Rajya Sabha has been given. So, just revise division of powers, existence of both central and state governments, supremacy of the Constitution, written Constitution, and Supreme Court as the interpreter of the Constitution, and representation of seats in the Rajya Sabha comes under the provisions of federal features of our Constitution. Now, after understanding the unitary and federal features of the Constitution, let us see some of the other features. Now, as we say, Article number 1, we are the union. We are the union. There are some people, there are some jurists who commented on our scheme of the constitution. For example, K.C. Weir. The K.C. Weir said that Indian constitution is federal in form but unitary in spirit. So you might get this here. These are the tourist names like K.C. Weir, Morris Jones, Granville Austin, and Evan Jennings. They commented on our constitution. So please remember K.C. Weir, K.C. W-H-E-A-R-E, K.C. Weir commented that Constitution of India is federal in form but unitary in spirit. Unitary in spirit. Morris Jones said that our constitution is of bargaining federalism. Our constitution is of bargaining federalism. Granville Austin, who was one of the most famous jurists at that point of time, called our constitution as cooperative federalism. The spirit of the constitution is like cooperative federalism. The Ivor Jennings commented that cooperative federation is centralizing tendency. So these are the comments which were given by Ivor Jennings. Ivor Jennings said that federation is centralizing tendency. Granville Austin said that our constitution spirit is cooperative federalism. K.C. Weir said that federal in form but unitary in spirit. And Morris Jones said that our constitution is like bargaining federalism. So these are the comments which are given by different jurists and which has come in examinations a lot. Now let us see that the position of president in our constitution of India. Now as we know that president is the head of the nation. President is the head of the nation. In India's parliamentary democracy, we have a ceremonial president. We have a nominal president or called as ceremonial president. The president holds a largely ceremonial role and acts as the head of the state. Now please remember, head of the state. President is the head of the state. Prime Minister is the head of the government. You might get a question, who is the head of the government? Prime Minister with its council of ministers acts as head of the government. And Prime Minister with the council of ministers aid and advise the President of India. So, as if someone asks, in an examination it comes that who is the head of the state or head of the country? President is the head of the country. And who is the head of the government? Prime Minister is the head of the government. Well, the president has certain powers and responsibilities, such as the president appoints the prime minister and other ministers on the advice of the prime minister. Please remember, one of the power of the president is that president appoints the prime minister and he also appoints the other ministers on the advice of prime minister. In England, in English system, in UK, as we know that there is a king and queen there. They hold, as similar we have a president, even the monarch holds a ceremonial role there. The monarch role includes duties such as opening of parliament, guaranteeing royal assent to legislation, but those actions are performed on the advice of the prime minister. The only thing is that we are not headed by a monarch, we are a republic, but we are headed by a president, whose roles are very similar in nature. So this will complete our role of president in our scheme of the constitution. Then let us discuss article number 12 of the Indian Constitution. The Indian Constitution, article number 12, gives the definition of state. Indian Constitution, article number 12, which is the starting article of fundamental rights. The fundamental rights are given under part 3 of the Indian Constitution from article 12 to 35. Please remember that the range of fundamental rights are 12 to 35. Article number 12 gives the definition of state. Article number 13 gives the judicial review. And article number 14, the right to equality. Then article 32 we have writs. Article 32 we have 5 writs. Then 33, 34 and 35. So many of the exams ask what is the range of fundamental rights. The range of fundamental right is article number 12 to 35. The very first article says that article number 12 gives the definition of state. Now, examples of definition of state are like State Bank of India, Zilla Praja Parishad comes under definition of state, cooperative societies. The some of the examples which does not come under the definition of state, like BCCI, Board of Cricket Control in India, and private unaided minority schools does not come under the definition of state. We have seen the article number 12 comes under the definition of state. Example of states are State Bank of India, Zilla Praja Parishad, cooperative societies, etc. And who are not comes under the definition of state, BCCI, then Board of Cricket Control in India, and private unaided minority schools. So just remember, in our examination, they will just ask you what is the definition of state and who comes under the definition of state and which article talks about the definition of state. Now let us see the preamble. As we have already seen, preamble was called as objective resolution. There are some ideals in the preamble and there are some objectives of the preamble. Now what is the importance of preamble? Preamble is the source of authority of the Constitution. Preamble reveals, preamble says what is the source of the authority of the Constitution. The very first line, we the people of India, that is called as popular sovereignty, is the source of authority of the Constitution. The Constitution derives its authority from its own people, not from any other source. Now, India is the nature of the Indian state. As the preamble says that Indian state is sovereign, Indian state is secular, Indian state is sovereign, Indian state is socialist, Indian state is secular, Indian state is democratic, Indian state is republic. These 5 words describe the nature of the Indian polity, Indian state. Then it also says the objectives of the Indian Constitution. It also says the objectives of the Indian Constitution. Indian Constitution's objectives are providing justice to its people, liberty to its people, equality to its people, and fraternity among its people. The nature of Indian state can also be called as ideals of the Indian Constitution. Ideals of Indian Constitution. And it also reveals, it also says what is the adoption and enactment date of our Constitution. As it is mentioned, November 26, 1949. Today we celebrate November 26 as the Constitution Day, starting from 2015. Then, the very first word, the very first object, the very first ideal of the Indian Constitution is the word sovereign. What do you mean by the word sovereign? Sovereign means India is neither a dependency nor a dominion of any other nation, but an independent state. The sovereign means India is an independent state. It is not a colony, it is not a dominion, or it does not come under any other power. India is a sovereign state, independent state. Second one, there is no authority above it and it is free to conduct its affairs, both internal and external. Now when we say it does not come under no authority is above it, it means that we can take our own decisions. We can determine which country do we have friendship or which country do we have the enemy. And we can rearrange everything in our country. We can demarcate, we can make a UT as a state or state as a UT. No one has the right to comment on it or interfere in our internal issues. In 1949, as we know that the very first thing in May 1948, Constituent Assembly ratified the Commonwealth membership. But in no way the ratification of the Commonwealth membership affects our sovereignty. It is very clear. And in the same way, the United Nations membership of India does not affect limit our sovereignty. We are independent nation. Now, in being a sovereign state, India can either acquire a foreign territory or give its part territory in favor of a foreign state. It also means that. Next. The second idea of the constitution is that India is a socialist country, sovereign socialist. Now let us see a history of the word socialist in our constitution. Congress party adopted a resolution to establish a socialist pattern of society in its Awali session early in 1955 and took measures according to it. Then India brand of socialism. Now when we talk about socialism, the very first thing which comes in our mind is of Russia. Now we do not follow the communist socialism. Socialism of two types. One is of USSR, but we follow the socialism is a democratic socialism. Our form of socialism is a democratic form of socialism. It is also known as democratic socialism, where people are the people. Rule is of the people in India. We do not follow communist socialism. We follow democratic socialism. Sometimes the communistic socialism is also called as state socialism. This involves nationalization of all means, production and distribution or abolition of property. Democratic socialism, on the other hand, explains that India have a concept called mixed economy. What is a mixed economy? In our mixed economy, both the private sector as well as public sector exist at the similar time, at the simultaneously, where government acts as a facilitator to the private sector, for the growth of private sector. As per the Supreme Court, democratic socialism aims to end poverty, ignorance, disease, and inequality of opportunity. So, what is the use of having a democratic socialism concept? Its main aim is to end poverty, end ignorance, end diseases, and most importantly, reduce the inequality of opportunities. Then we have the Indian socialism. When we say the democratic socialism, again, what is the democratic socialism? Our socialism is a mix of Gandhian socialism, Marxism, and Gandhian socialism. Second, the next important point is the word secular. The third idea of our preamble is the word socialism. The word is secular. We have discussed the sovereign, we have discussed the socialism. Next, we are going to discuss the word secular. Though we added this word secular in our preamble by 42nd Amendment Act 1976, the spirit of the Constitution was secular in nature. The right to freedom and other provisions made Indian Constitution as a secular constitution. The term secular was added in our preamble by 42nd Amendment, Constitution Amendment Act of 1976. Though it was challenged in the Supreme Court upheld this amendment and commented that what was inclusive was made explicit. As for the Supreme Court said that there can be no doubt that constitution makers wanted to establish such a state, and as for the article number 25 to 28, which guarantees the fundamental right to freedom of religion, has been included in the constitution. So please remember, our constitution is a secular by its nature from the very inception. Next, let us understand. So let us look at some of the cases regarding the preamble. In 1960, there was a question in front of Supreme Court to decide whether preamble is part of the Constitution or not. Preamble is part of the Constitution or not. In 1960, the Supreme Court said that preamble is not part of the Constitution in the famous Belugari Union case of 1960. But it said that preamble is a key to the minds of makers of the constitution. Now, if we want to understand the minds of the constitution, we have to read the preamble and understand the thought process which was running in the constitution makers after 1947 to 1950. Later in the Keshavananda Bharati case, in 1973, Supreme Court reversed its stand and said the preamble is a part of the constitution. And again in 1995, in the LIC case, the Supreme Court said that preamble is an integral part of the constitution. So three most important cases regarding the preamble is Veruvari Union case 1960, Keshavananda Bharati case 1973, and the LIC case of 1995. Then let us look at the justiciability of the preamble. Now, as we say that preamble is a part of the constitution, but there are limitations. What preamble is not? Let us look what preamble is not. Preamble is not source of power to the legislature. We get them from the constitution, but preamble is not the source of legislature. It neither acts as prohibition upon the powers of the legislature to make any laws. It does not put any limitations on the legislature. Preamble is not justiciable in nature. Preamble is not justiciable in nature. Though it contains all the ideas, all the objectives, but still, as per the many jurists, we call preamble as not justiciable in nature. What is not justiciable? Any citizen cannot approach court for its enforcement. Then we have preamble is not enforceable in any court of law. As it is not justiciable in nature, it cannot be enforced in any court of law. So by this we complete our most important topics. Let's take a break and then we'll start after 5 minutes.